I'd like to call the meeting to order. Good morning, everyone. Welcome to the Barrie Police Service Board meeting of June the 20th, 2024. I'd like to begin with our land acknowledgement. In keeping with Indigenous protocol and building respectful relationships between Indigenous and non-Indigenous peoples in Canada, it is customary to acknowledge traditional territories and ancestral lands of Indigenous people. We would like to acknowledge this sacred land on which the Barrie Simcoe Emergency Service Campus operates. It has been the site for human activity for 15,000 years. This land is the ancestral land of the Wendat and Anishinaabe Nation. The treaty that was signed for this particular parcel of land is collectively referred to as the Williams Treaty. We are dedicated to honoring Indigenous history and culture. We also recognize the enduring presence of Indigenous peoples on this land and are committed to moving forward in the spirit of reconciliation and respect. Thank you. Our agenda for this morning was distributed in advance. A motion to approve the agenda. Second. Mr. Ron, any questions, comments, changes, etc., related to the agenda? Seeing none, I will advise that the mayor did send his regrets. He had a scheduling conflict this morning, so he will not be joining us. Any conflicts of interest to be declared by any members with respect to today's agenda items? Seeing none, thank you. Also distributed in advance for the minutes of our meeting of May the 23rd, 2024. A motion to approve, Mr. Don. Deputy Mayor Thompson, any amendments, changes, questions with respect to those minutes? Seeing none, those in favor? Thank you. We'll move forward. I'd like to introduce Mr. Tom Gervais. He's with the Solicitor General. He is the Police Service Advisor for the Barrie Police Service and the Barrie Police Service Board. Tom, I'd like to ask you to come forward and say a few words and introduce yourself to the board and see.
So, how am I doing here? Thank you, Mr. Chair. I asked for a couple of minutes on your agenda to introduce myself. Likely familiar with colleague G.D. Sahota, who's been assigned to the board for actually many years. So, our work on behalf of the Inspector of Policing is both advise the board on compliance issues, compliance matters. There's a commitment with the Inspector General that our advisory role isn't limited to compliance. It's to assist the board as best we can, within the framework of the new legislation for the inspector. In addition to the advisory role, we have a monitoring role as well. We monitor the board compliance, monitor the board members for misconduct. Not that we expect to see that. One never knows, and so on. So, in that capacity, I'll be engaged with the board. Temporarily, Judy's been reassigned to active manager role within our office, and she was in that capacity, no longer able to manage some three, including Barrie. So that's the decision was made to redistribute some of the workload. Through that, I picked up what she asked me to do, take care of Barrie. I'm also looking after Toronto, and my regular zones are zones 1 and 1A, which is Northern Ontario. I started Barrie Sound and go north to Quebec to Manitoba, which I do out of my home here in Windsor. So that's in a nutshell is who I am, what I do, my role as the board. I have a similar role with the chief of police, monitoring the service himself for compliance. So it's a pretty broad spectrum of responsibilities. Any questions, concerns?
Questions or comments? Especially currently with the introduction of New act, the first and all the changes of all that. So maybe you need to more than that.
You're very welcome. And on that point, I think there's a lot to be done, keeping compliance with the new act, and I'll provide whatever assistance I can to both the board and the chief. That's good.
Sorry, thanks, Chair. Sorry. But, friends, where I live by surprise, that working with us directly, but it might be temporary. But great opportunity. And I will tell you that it was a very immersive conference, and it's a lot of things with more so than what I had experienced back in February, I guess. The initial announcement. You would echo your comments and things that there was probably Mr. Chairman.
Thank you, Councilor. Thank you for taking the time. Next on our agenda is deputation. Management started basically after the approval of the 2024 budget, getting our 2025 fiscal budget. So staff has been working on that. We will, in August, budget subcommittee will be looking at a first draft fiscal 2025 budget. But leading up to that, we posted the opportunity for any members of the public come forward with a deputation or provide commentary. And we did receive one with us this morning, Mr. Pierce, who's taking the time to come see us and provide his comments as we move forward to 2025. As I know that you have provided the rules with respect to deputation in advance. Look forward to hearing from you. The floor is now yours. So you have 5 minutes.
All right, thank you. Good morning, everyone. Nice to see you all again. It would be nice to see the mayor here. It's the second year in a row he's missed these deputations, so that's very unfortunate. So most of you know that I'm not a big fan of policing. Now, I don't say this maliciously. I simply don't believe police are very valuable when it comes to preventing crime and helping solve some of the problems plaguing our city and our society. After all, the police were created by the ruling class to keep working people, the poor, Indigenous, and racialized people in line. And this history cannot be viewed on its own at a certain point in time, i.e. when police were first instituted, but it must be analyzed and examined as part of a lineage that remains with us today. We are told that the police are the bringers of justice, that they are here to help maintain social order. The neutral enforcement of the law sets us free, so they say. This understanding of policing, however, is largely mythical. Police function, despite whatever good intentions they may have, as a tool for managing deeply entrenched inequality in a way that systematically produces injustices for the poor and socially marginalized. As Noam Chomsky said, if you don't have wealth, if you don't have power, then you don't have rights. It's the way the world works. Your rights correspond to your power and your wealth. To contextualize this for Barrie, an unhoused person living downtown simply doesn't have the same rights as someone living in a nice single family detached home in Painswick. Whether you're willing to admit it or not, this is the reality in Barrie. Police are designed to protect the person living in Painswick at the expense of the person struggling to survive, maybe in an encampment downtown. Yet, despite these glaring faults, we've seen the police budget continue to increase here in Barrie year after year, even as more and more people say that they still feel unsafe. This isn't a surprise. Giving more money to the police doesn't actually affect the crime rate or crimes of it. There have been numerous studies to back this up too. Whether it's last year's study by the University of Toronto and the Upstream Lab, or the 2014 report by the Fraser Institute. Research conducted by both progressive and conservative organizations has found no consistent correlations between police spending and municipal crime rates. Of course, police and politicians argue that residents in high crime communities demand police action. What is left out of these discussions is that these communities also ask for things like parks, libraries, and better transit, just to name a few. But these services are rarely provided. Modern policing can, therefore, only be seen as largely a war on the poor that does little to make people safer or communities stronger. And even when it does, this is accomplished through coercive forms of power that can often damage lives. Police can't be asked to solve society's problems. And I think a lot of us would agree with that. But that's what we continue to do here in Barrie. What is missing from our city's current approach to police funding is any critical assessment of what problems the city is asking the police to solve and whether the police are really the best suited to solve them. If we were to redirect the millions of dollars that now go towards Barrie Police, move it towards providing things like housing or shelter spaces, mental health supports, better transit, solutions for the toxic drug crisis, etc., there would be less need for the police in the first place. So what exactly am I asking for this morning? Well, first, I think we need a better public consultation process. There was very little notice about this meeting. There was only 2 days notice before people had to submit the application request. 8 a.m. I think is too early. I think an evening consultation would be better and get more people up here. And I think a more neutral location. The police station is a very intimidating place to be standing up here. I don't mind it because I've been doing it for a while, but a lot of people do find it intimidating, especially if they've been involved with the legal system. Next, I think a hiring freeze that coincides with the transfer of city funding from police towards services, helping the unhoused and our most vulnerable in the city is needed. This should be followed by a period of civilianization of some police functions after a comprehensive engagement and consultation with community groups. We've seen the rise of layered policing in this community, but really is asking the police to be the lead agency in dealing with so many issues the best approach. I say it's not. Finally, the offloading of more core police responsibilities to the municipalities would be one of the last steps. We need to invest in our citizens. It's the only way to build a city that will help meet people's human needs. I understand the resources are limited, especially under this current city council, but people need help. They need the services, they need positive resources. Therefore, the main fact before us is that the money that will be needed for this is going to have to come out of the police budget. Now, we've seen a softer image of the police recently, but here's where I'm going to be blunt. You can dress up police officers to look like camp counselors, give them cool off-road vehicles, post smiling faces on social media all you want. It doesn't change the fact that people in this city are hurting because we continue to hand the police too much money. That's simply the truth. As sociologist Alex Vitale said in his book, The End of Policing, quote, a kinder, gentler, and more diverse war on the poor is still a war on the poor. Defund the police and invest in community. Thank you.
Questions from the board? Yep. Being done. Yeah. There were 8 items in our consent agenda: directions to the chief, community partnerships, auxiliary and special constable appointment determinations, human resource report, public complaints, systemic review update, 2023 annual budget, and annual report, 2025 budget timeline. Are there any items in the consent agenda that we would like to hold, or any questions with respect to that we are providing in advance? On a motion to approve. All those in favor? Thank you. As our service continues to grow, there are a number of appointments that require approval. Appointment of new auxiliary members. Motion to approve the appointment of the following new auxiliary members of the Barrie Police Service as per Section 91, Sub 1 of the Community Safety Policing Act. The names that are in front of you, motion to approve those appointments. John, any questions, comments? Seeing none, those in favor? Thank you. We have the reappointment of a number of special constables. Entertain a motion to approve the reappointment of the following special constable members in the Barrie Police Service pursuant to section 92 of the Community Safety and Preaching Act, regulation 96. And the names are listed there. Strong, any questions, comments? Strong, please.
Question. I wonder how long the appointments are valid for. I just don't know.
According Chair, and according to my subject matter expert, in about 3 years.
And that's legislative 3 years, or is that our policy?
Legislative.
Thank you. Definitely. Any other questions? Pay for the motion. Thank you. As we've seen in the past, obviously our 2025 budget is not complete, approved, but in order for the service to purchase vehicles, we need to place the order now. 2025. So it is common, I believe, in every year that I've been on the board, a motion to entertain to allow service to purchase the vehicles they expected to buy. The motion is to approve the release of 2025 budget capital funds in the amount of $361,000 for the pre-ordering 6 frontline vehicles. Second, John, any questions or comments? Please.
Thank you, Chair. Just, Mr. Turner, I don't know if I'm putting you on the spot here, so I apologize. Is there any information that we have historically, as actually we have done this in the past, better, just keeping in mind though, we are earlier in our budget cycle as well. I'm just curious, have we ever, in your knowledge, or to your knowledge, had an indication where pre-ordering had a negative impact as we got closer to budget or approval time?
Mr. Chair, so the predicament we're facing this year, which we haven't faced in previous years, usually you'll see this request come at the September board. So what has happened is hybrid Explorer only sold these services. That's a decision the board has made, and that's the vehicles that we're looking for, both for cost savings and fuel and maintenance. What the board did is they ceased production of hybrid police explorers. So we actually didn't receive that much. So that's why we're getting first in line when they open production up, and the only way we can do that. We're at the mercy of the
Thank you. Thanks, Deputy, and thanks, Mr. Turner. Recognize that where there are supply issues, obviously referenced in there. Just out of curiosity, if after we put in our order, if there was a change of policy or the indication came to light where it determined those are not the right fit for us, we have them out in any way, shape, or form based on your.
yes, we've both Ford and many police services have altered their order after it's been fixed. In fact, we have Ford replaced our previous hybrid order with all straight fuel orders, straight fuel powered orders. We actually declined that. It just wasn't economically feasible or smart from a fleet perspective. So we can maintain the fleet for next year in the anticipation. Ford has said, as I said before, that the hybrid Explorers will be coming, and that is our preference to try to maintain the fleet and looking forward to the future.
Yeah, the reverse of your question about risk of not getting approved. There's far greater risk of not doing it and not getting the vehicle at all. And so, other question. All those in favor? Chief, I'll hand it over to you to introduce our special guest, Ms. Saunders, this morning, who's going to apply to the board's respective bail reform.
Thank you, Board Chair, and request on behalf of the board and the organization to our Crown Council. Over the earlier board meeting where there was a desire to better understand the ladder principle, but poorly explained it probably, and I think excellent opportunity for the board as well as our community to better understand landscape we find ourselves. So I really do lean on this. She's been Crown Counsel since her call to the bar in 1991. Initially with the Newmarket Crown's office, then the Barrie's Crown's office beginning in the fall of 1995. Lynn has been a Crown attorney for Simcoe County since July of 2015. He's part of an office of 26 lawyers and 15 administrative staff responsible for the prosecution of the Barrie and all of Simcoe County satellite courts, including Bradford, Collingwood, Midland, and Pavilion. I have known Crown Saunders since I started here in 1998. Found her to be a highly intelligent, engaged, progressive thinker, and she's a highly valued justice secretary.
Crown Saunders, welcome to the Barrie Police Service Board, and thank you for taking the time. Appreciate it very much.
Good morning. It's a pleasure to be with you. As you've heard, my name is Lynn Saunders and I'm the Crown Attorney for Simcoe County. We work very closely with Barrie Police, so I was quite happy to make myself available to offer a bit of an overview with respect to the principles applicable to any questions that you might have. The approach to bail really was overhauled in 2017 as a result of a case out of the Supreme Court of Canada called Antic. Prior to Antic, it had been very much analysis of risk in bail court as to whether or not someone was going to be able to secure pretrial release or not. Supreme Court of Canada in Antic effectively said, look, your starting point is wrong. You need to begin presuming that someone is going to be able to be released while they have charges outstanding without any conditions and that they can carry on in the community. And so what Antic introduced was a principle called the ladder principle, effectively saying that you have to climb each rung of the ladder. As you climb the ladder, and we'll look at it in a moment, the restrictions on a person's liberty get increasingly more serious. And what Antic and the Supreme Court of Canada dictated is that you only climb the ladder as far as you need to in order to safely release that person into the community. So that's the starting presumption. The ladder principle sets out basically options for the pretrial release of a person charged with an offense. And the presumption identified by the Supreme Court of Canada and then adopted by Parliament and now embedded in our criminal code is that an accused will be released on an undertaking without conditions. So really just a promise that they're going to come back to court. Unless it can be demonstrated that a more onerous form of release is going to be required. This is a pictorial demonstration of the ladder, and I understand what you were interested in learning more about today. You will see at the very bottom left of the screen, release called the release without conditions. And really what that contemplates is if someone is going to be charged with a criminal offense, but there's no concern about them reoffending, police know who they are, there's not a concern that they're not going to show up for court, nothing is required in terms of supervising that person in the community. The theory is all that person really needs is a piece of paper giving them a court date. So that's at the bottom end of the ladder. If the police are of the view the person can still fairly be released, we can trust them to abide by sort of minimal conditions in the community and come to court. The next step up the ladder is an undertaking with conditions. And what that really requires is the police to give the accused person, again, a document, a piece of paper saying, here's your first court appearance, but here are some conditions we need you to abide by while you're in the community. Could be not communicating with certain people. It could be staying away from a certain location. So fairly gentle conditions that don't require a whole lot of oversight. If police come to the view based on what they know of that individual, that an undertaking with conditions is not going to be significant enough to be able to control that person's behavior in the community, then the next step up is what's referred to as a recognizance or a release order. The difference between an undertaking and a recognizance or a release order is that in a release order, there's often a sum of money attached to it. More often than not, the accused person doesn't actually need to pay money. It's simply a promise to pay if they breach any of the conditions. So it's sort of akin to, when your kids go to school and you tell them they need to contribute to the university education because they need to have some skin in the game. That's the purpose of a release order with an amount of money attached to it. The next step up the ladder requires a recognizance or a release order with a surety. A surety is basically a person in the community who's going to accept responsibility for monitoring that accused person while they're on bail to make sure that they abide by the conditions. Quite often, we will see a spouse step up to monitor their partner or a parent in relation to their child who gets in trouble. Sometimes it's an employer or a sibling. It's somebody in the community who says, I'm going to be their jailer outside of jail. I'll make sure I know where they are. I'll make sure they get to court, and I'll keep an eye on them to make sure that they're abiding by those conditions. So that's the next step up the ladder. As we continue to move up the ladder, you'll see the next one is recognizance without sureties, but with deposit. So again, they're going to be released. They're going to get some conditions. They maybe don't need that babysitter in the community, but that skin in the game that we were talking about, that it's just a promise to pay. Now we actually need them to put down the money. They need to know that if they don't come to court, we're keeping that money. It's not just a promise to pay anymore. It's actually depositing the money with them. And the amount of money that we're talking about is really geared to the person's ability to pay, as well as a reflection of the seriousness of the offenses. So you may have someone whose promise to pay is $500. You may have someone who has considerable means, and in order to sort of bind their conscience with respect to the importance of the conditions, might be $2,000 that they need to deposit in those circumstances. Continuing to move up the ladder, so we're now at the second step from the top. You see a recognizance with sureties and with a deposit. So that's sort of as high as we can go, as restrictive as we can go, with the person still being able to be released. So that would be a release order with conditions. It would require a surety, a supervisor in the community, and a deposit. They also have to put money down that gets deposited with the court. And we most often see those sorts of release orders where somebody is not ordinarily residing in Ontario, whether they're, from the States, they're here on vacation, and they're involved in committing a criminal offense. We need to make sure they're going to come back, or even if they're out of province, we can require them to deposit money. Again, the incentive being we want to get them to come back. At the very top end of the ladder, if as we move through these stages, trying to see how much is required to secure a person's good conduct in the community, if we really just can't come up with a plan that we think is going to ensure their behavior in the community, the final step is a detention order. And a detention order means that they remain in custody until they have a trial or preliminary inquiry. So there are a number of options for release, the first of which are options available to the police. So an officer who arrests someone has the ability, discretion, based on what they know of that person and the seriousness of the charges that they're facing, to release them on a summons or an appearance notice. And really, that is nothing more than giving them a court date, a little document saying you've been charged and you have to report. If the arresting officer believes that conditions are going to be required, whether it's no contact or staying away from a specific location, then that accused person has to be brought into the police station and they're assessed by the officer in charge and conditions are set. If the police come to the view that there are either the accused person should be detained, that they simply cannot be safely released into the community, or that there are certain conditions that they think are going to be necessary to secure that person's good conduct, but they're not conditions that police can impose at the station, only then can an accused person be held for bail. And again, the criminal code sets out what the bases are for seeking someone's detention. There are two. The presumption in the code is that people are going to be released, but people can be held for bail and in fact detained if there are reasonable grounds to believe that the accused will not return to court. So the sorts of factors that we might look at to decide whether that's a basis on which we want to seek detention or whether someone has prior convictions for failing to appear in court. We may want to look at whether they are from elsewhere. So again, it might be somebody who's come to Simcoe County on vacation, but they're ordinarily residents in Iowa, and we're not worried they're going to come back. So the first condition, referred to as the primary grounds in bail court, is whether there is a concern that someone is going to return to court. If we're okay and we think, okay, yeah, they're a good risk, they're going to come back to court. The only other basis we can look at in the context of a bail hearing to decide whether someone should be detained is whether it is necessary in the public interest that the person be detained, having regard to all of the circumstances and the need to establish their identity, because sometimes there's a concern about whether the person they're identifying themselves as is genuinely them. Is there a concern about the need to secure and preserve evidence? So are police concerned that with this person they've got in custody, they have access to weapons at home? Maybe there's a need to be able to execute a search warrant before this person can safely be released. The other bases on which to decide that there is too much of a concern to allow somebody to be released is whether there is an articulable concern that this person is going to continue to commit offenses. So in that respect, police may look at their criminal record, for instance, and see whether they have been someone who in the past has either breached court orders or who's been involved in this sort of thing. And then the final basis on which we can seek to detain in a bail court is where there is a concern for the safety of victims or witnesses that cannot be attenuated if someone is released. There are a list of conditions that police can attach to an undertaking in the police station, and these are they're drawn straight from the criminal code. Parliament has been very strict around what conditions police can impose, and then if something more than that is going to be required, the accused person has to be held for bail, and a justice of the peace can impose. So in terms of the conditions that police can impose, they include remaining in the jurisdiction, notifying change of address or employment, because police need to know where to find people if they need to serve documents on them or just do a compliance check. Police can prohibit someone from communicating with a victim or witness. So we often see this in terms of intimate partner violence cases, where an accused person is going to be released on a condition that they not communicate with their victim partner. Sometimes police can require an accused person to deposit their passport if there is a concern someone perhaps has dual citizenship and you want to make sure that they're not fleeing to another country where they have significant roots in the community. You can try and secure their travel documents to prevent that. Another one police will often use in relation to offenses of violence is abstaining from possessing a firearm. Firearms are a plague on our community these days, we all know. And so that's a very important condition that we see on virtually any bail order that relates to any sort of commission of violence. Police can also require an accused person to report to them. So it's really just a check-in. It can be once a month, once a week. It can be once a month, depending on the person. We quite often use that condition in relation to folks where you just want to make sure they're not disappearing. If you've got someone who's got roots in a bunch of different places, you may look at their driver's license history and see that, for a year they lived in Toronto, then for 8 months they lived in Oakville, then for 12 months they lived in Collingwood. They're really kind of moving around. It's important to be able to keep track of those folks. So you may want to include a reporting condition. Abstaining from drugs and alcohol is still a condition that police can impose. But as a result of a number of cases that have been released from the Supreme Court of Canada since Antic, police and courts are really discouraged to try to impose conditions around the use and abuse of substances on folks who struggle with substance misuse. The challenge is that by imposing that sort of a condition, you are setting that person up to fail. They're going to breach that order because they are suffering from a condition that they simply can't abide by it. So we often see courts frowning, fairly on the imposition of conditions that it's really just not realistic for a person to be able to abide by. So things like someone who suffers from alcohol addiction, you can't tell them not to drink. That's simply not a condition that is going to be imposed by a court and upheld. Similarly, for people that struggle with homelessness, we're going to have a difficulty asking them to report to police because that's going to be troublesome for them to be able to get to the police station on a regular basis to be able to report. So the idea is that we have to impose, whether it's at the police station or in bail court, the kinds of conditions that are minimally required to secure good behavior in the community to attenuate the risk that they're going to commit other offenses, but also be conditions that they can realistically abide by. And that's really the balancing. So it's not so much the risk assessment that we had for many, many years. This is the new sort of lens that we're looking at sail through. The one last piece of information that I'll share a little bit about in terms of the bail court. Is a provision in the criminal code that says when an accused person is held for bail, if they find themselves in a certain circumstance, the onus is then on them to demonstrate why they should be released. And there's a list of situations that's taken from Section 515 of the criminal code that sets out when a reverse onus is found to be met. The one that we see the most often in bail court when somebody comes in is they're already on a release. They already are on bail or other outstanding charges. That puts them then in a reverse onus position. So it's up to them to demonstrate to a justice of the peace why they should be released again. Similarly, if one of their charges is failing to appear in court, so they've already had a release and they didn't show up when they needed to, that generates a reverse onus. Simply because an accused person finds themselves in reverse onus position in bail court doesn't mean they won't get out. It simply means that they're the ones that bears the brunt of explaining why they should get out. So they need to come up with a better plan, whether that's a surety that they can live with, whether it's somebody that they work with, so they're going to be spending a significant portion of their day with them, or whether they're proposing actually house arrest, that they're going to be in this person's home at all times. So this person can keep an eye on them 24 hours a day. The reverse onus provisions are helpful insofar as they require an accused person to demonstrate why they should be given another chance. And the last slide is really just a reference to a new position that we have in a number of Crown's offices throughout the province, and we certainly have them here in Barrie. We have something called bail vetters. So it's lawyers in my office that each day are assigned to review all of the cases that are coming into us for bail. They have a really deep dive into the cases. They're in touch with police if they need additional information, and they're making sure that we have all of the information that we require in order to take an informed position about whether that person should be released on consent at a bail court, or whether we should be running a hearing, seeking a surety and conditions, or whether we should be seeking their detention, that they've simply gotten to the point where the risk cannot be managed in the community. So those are folks that are available all day, every day, Monday through Friday, for police to call into. In order to get advice and for us to liaise with to make sure that we've got all of the information that we need. We run bail courts 365 days a year. So their bail courts run on weekends, on statutory holidays, and all of these same rules apply. It's a little bit more like meatball surgery than sort of a Monday to Friday bail court. We don't have every single weekend a bail vetter, but we're getting there because we're finding that even on what we call wash court days, weekend statutory holiday bail courts, we're still dealing with 15 to 20 bails between all of Simcoe County and York Region. We run a shared bail court, but all of the same considerations will apply regardless of what day of the week an accused person finds themselves arrested and should work with that. So that's an overview of the bail scheme. It is not unusual for police to come across somebody who has 5 or 6 sets of outstanding charges. Because we're working with that ladder principle, we can't sort of jump to the top of the ladder until we've given other options for release a try. And so it's frustrating, I'm certain, for police. It's frustrating for Crowns as well. And I think it's sometimes difficult for the public to have an appreciation as to why somebody is out on multiple forms of release. But it's really because we are constricted by that ladder principle, identified by the Supreme Court of Canada in Antic, and then adopted by Parliament and embedded into their criminal code.
Saunders, thank you very much. That was an excellent summary, and your conclusion was the reason why we asked to we're constantly, as members of the community, asked to read this in the paper and release it on their own. I think the general public is struggling with that concept when they read what the charges are and then they're immediately released. That's a question I get a lot. Mr. Connon, a question, and Deputy Mayor Thompson. And then Mr. Connon.
Thank you, Colonel Saunders. I certainly appreciate the presentation, and I'm glad you went first, Chair. I'll be honest with you. There's so many things. If we had 10 hours, I don't think we'd have enough time. your closing comment there obviously is the restriction sort of imparted upon the Crown and the courts based on that precedent that's been set. I guess my first question, very briefly, as best I can, is that something that's challengeable going forward?
It would require amendments to the criminal code.
Right.
So really, if there is going to be a change to the latter principle, if there's going to be shortcuts, for instance, that are introduced, that's something that will need to come from the Supreme Court of Canada. They are the only ones that can override their own decision in Antic, and then changes to the criminal code made by Parliament.
Trying to summarize the points down on one question. And I appreciate that you are not the court, and I appreciate you're not a police service as well, and et cetera, each knowing our rules. I suppose if I was to vocalize the thoughts of the community is in terms of whose role is it to create the business case around the level of concern regarding reoffending or harm to the public, and if I could put one case, or maybe it's drug trade or driving under the influence. We do hear, to the frustration of many in the community, concerns around, even locally and recently in this community, someone who finally killed somebody who finally took out 3 or 4 people on the way to a hockey game, for example, locally. I'm sure you're familiar.
Mhm.
And this person has a history. So that latter principle, did it work? It is really, I mean, I got 10 more questions, but I know we don't have time.
No, I know exactly. It's very frustrating, and I can tell you that, folks of my vintage, this is not the bail system that we grew up with. If you didn't sort of get continuous kicks at the can to see if, okay, let's put one more layer of restriction on and see if now you can behave. So it's very frustrating, and the kinds of submissions that the Crowns are making in bail court are exactly what you're talking about hearing from the community. Courts are often saying drinking and driving is a scourge in our community. It's a privileged office. Well, that's what the Crowns are saying on these bail hearings, with a view to trying to seek detention. But the judges and the justices of the peace, primarily JPs that are presiding over bail hearings, their direction flows directly from Antic, that people are presumed to be released without conditions. And it's only if you, Crown, show me that additional restrictions are going to be required that I can impose them. So it's a challenging system to work within. We run a bail court in Barrie all day, every day. That's how many people are coming to our bail court, and we're running hearings because we don't think that they can safely be released. So it's a full-time job. In terms of who can make a difference, you've got public interest groups like MAD. You've got various community groups who are upset about the prevalence of a particular type of crime in their community. I think if they approach their members of parliament, their members of the provincial legislature, and let me know that this is of concern, that's the sort of traction I think that we need to try to make change with respect to these principles.
No easy task. Thank you very much. Appreciate it.
Thank you, Chair, and thank you, Councilors. Some of the same, and I actually won't go down the same road. It's simply hearing about it in the public. The thing that concerns me is, and I think people don't understand, this is passed down by the professor.
Yes.
That you have to work within the framework. And I just believe from where I'm sitting, we've actually lowered the bar. When you say you can't put condition to refrain from drugs, when Crowns and people in policing know that more than likely the person, if they suffer from it, is the reason why they're being charged. It's to feed the addiction. So if we can't refrain from it, they're obviously going to look at that. So, but if we look at some of the heinous crimes, with an officer already here, it's not there. And that's the frustrating part. And then the one thing I saw, or I wrote down, was it's the release by police in like their own under the station and stuff. You believe that the police are prepared that all, or they understand that that's not where they're actually making calls based on how they're
To some extent, I think that you can't avoid going down that road. Holding somebody for bail, putting together the extra documentation that's going to be required, that's additional work. And so I think if police are of the view that this person is only going to be released in bail court anyway, there probably are some officers that will decide just to release them from the station. I can tell you that I think all of the police partners that we have in Simcoe County, including Barrie Police, are very diligent around when they can release and when somebody should be held for bail. And they're very good about articulating what the concerns are. So we find that the police work with our bail vetters each morning. They start at about 7 o'clock in the morning, going through the incoming arrests, identifying the risk factors, identifying if there's additional information that we require in order to be able to make a case for detention at a bail hearing. So I think that the police are really, we've been working with this system now for a number of years. We've come over and done some training with Barrie Police and with our other partners throughout Simcoe County. And I think that they're very attuned to what has to be available to a court in order to be able to justify detention.
My final one is, you have the number of
I don't have that number at my fingertips, but I can tell you it is not unusual for us to see people in bail who have 5 and 6 sets of outstanding charges. Now, that's not to say that they're out on 5 or 6 sets of violent offenses, but they might have back from the LCBO, then they've got to breach probation because they didn't report. So they may have more minor things. And then when they come in with something more serious, that's when they're going to be held for bail.
stock.
Here, I have a couple of questions. One is just in relation to the bail court. So you're running bail court every day of the year, all day long. What is the average or typical outcome of that? Like if you're putting together with police a case to detain someone or to like go up the ladder, what's the success rate of the Crown and the police working together to achieve that? I don't know how long it's a question, but anyways, what's like the outcome? Are you progressing the way you want to?
We are. So I can tell you as well that there's a new initiative called the Intensive Serious Violent Crime Bail Team. And really what that does is we are putting extra time, extra resources, extra eyes on cases involving offenders who are alleged to have committed very serious violent offenses where there's some indication in their past that they've behaved similarly. It's an initiative that was come up through the Ministry of the Attorney General, through my employer, and partnered with all of our law enforcement partners. We've got dedicated officers. And so people are flagged at the time that they're arrested, like, hey, they might fit this protocol. It's a much more intensive look at their background in particular. They tend to result in much longer bail hearings. They might take a whole day instead of an hour, like the garden variety one might take. And we found in relation to those where we really take the time to do a very deep dive into that person's background. We get lots of information from the police around just how provable these charges are. We find that those folks don't even want to have a bail. It's almost like they see the writing on the wall. So the last set of numbers I saw, I think we had about 80 of them or so flagged just in Simcoe County. So it's not just Barrie, it's all of Simcoe County. I think about 15 of them had had a bail hearing and been detained. 12 of them had had a bail hearing and been released, and the rest of them didn't even have a bail hearing. So they're still sitting in custody. They're not even going to take the chance to have bail because we've been able to invest that much effort into making sure that we are as absolutely well prepared as we can be, because we recognize that that person poses a safety risk to members in the community.
In follow up to that, can you provide just a couple of examples of what types of crime fit the bill for this program?
It would be someone who's, they might be out on offenses of violence. So perhaps they've got a release on an assault with a weapon in relation to another kid at school or something like that. And, now they're involved in a convenience store route. So you're looking at them thinking there's an escalation. It may be this person may come from a situation where there's nobody really available to supervise them in the community. So maybe they're looking to be supervised by bail program, which, that can make sure that they've got a place to sleep at night, but that's not really keeping track of them during the day. We will also look at someone's criminal record to see if they have other convictions for violent offenses and convictions for breaching court orders. That's obviously something as well that's very important to us in the context of bail. If somebody is breaching a court order every year or every other year, we can't really have any confidence that they're going to pay attention to a bail order. So those are the additional pieces of information that will help us build a better case for detention, if that's what we ultimately decide to.
My last question relates to conditions back for people and people who are released around intimate partner violence. And so, for example, like the police could just release as a patient and say, you know, don't go to your partner. That's like, that's their family home.
Yes.
Potentially. And there's so many circumstances that bring partners back together.
Yes.
There's a lot of research on that and nothing to go into all of it, but my question really is, how are we supporting the victim of that violence? And maybe it's more of a question for the chief or for you, but like as a community, how are we ensuring that there's not a reoffense, that we're not re-victimizing that partner or the members of that person's family?
So I'm happy to let the chief speak to sort of what the police do on the ground in terms of making sure that that victim is safe. But I can tell you that sort of once the case makes its way over the court process, we have the Victim Witness Assistance Program embedded in our courthouse, and they are service workers whose job is to do outreach to victims to, if they need any kind of services, access connecting to them. They're involved in that. They're also sort of a liaison between my office and a victim. So they may talk to a victim whose spouse has just been arrested and detained in custody. And feel that victim is really very needy. They don't understand the process. They need to sit down and just understand what the landscape looks like. And the service workers have a lot of that information. And so they spend hours and hours and hours on the phone or actually meeting with these folks face to face. And they'll also contact my office if they feel that somebody has, you know, questions that really need to be answered by a Crown. Standard sort of bail variations or bail conditions in intimate partner violence cases, you're right, often do keep the offending partner outside of the home. We quite often see conditions like not attend at, not be within 100 meters of their partner, not be within 100 meters of their place of employment, their place of residence, their place of worship. And that does pose a challenge for families, particularly if it's the principal breadwinner that's not permitted to be in the house. And in those circumstances, it is a challenge because I think those kinds of conditions can serve to alienate the victim, the non-offending partner, and really discourage him or her from wanting to participate in the process. They just want these conditions to go away. And so we're constantly getting feedback from them around what the hardships are around those conditions. And if we can ameliorate that by varying the conditions somehow without increasing the risk that that person is going to be at, then we're open to doing that.
Running a little long on time, so that's great. Got a lot of I have one question. It's for the chief, but I with Crown Saunders here. What kind of it's more in terms of I look at the risk that's going to what point in the ladder Crown's office is better contact or with where that's why they should follow it.
Thank you for the question, Chair. So depending upon the circumstances of the contact, so with the most serious of offenses, and we're talking at the very high end or what we would consider the most harmful offenses within our society, we often contact the Crown's office. And while it may seem straightforward, we just want to have our ducks in a row with respect to homicide or a violent sexual assault. There's some of the lower harm offenses, which we still have victims for, even if that we recognize that will happen. There's a lot of officer discretion. And the reality is, there's an expectation on our officers who are aware of the latter principle. If there's no need to reach out to the Crown. So if I'm a first-time offender, I stole a chocolate bar. That's not an example, because perhaps that charge is supposed to be a charge. We recognize I've had multiple, 2 or 3 chocolate bars. The reality is there's no the requirements for the suggestion of bail. They would have to be some pretty extenuating circumstances to suggest that there was a requirement to have that.
Yes, there were different regions and stats, but if you look at the bigger picture. So our officers are doing construction there, there's an expectation of an awareness of the training you've been given, and some thought process before you jump to action, which, and I recognize it is a great expectation within our community. We are part of the justice system and we recognize the limitations of it, but that is the system we have. Been at a number of town halls and speaking to the board, but also our community. I recognize there is a desire to see focus on an area within our system that is at fault. Continue to that we're doing the best we can, and our justice partners are doing the best that they can. We live in a world, in a country of law, guided by laws, and they come from case law. Even our JPs and the judges, they're bound by what they do, by the very laws that we create at the Constitutional Law. So there is no one pain point. It's the nature of the system. It takes challenges, but there is expectation of our office.
Thanks, Chief and Town Saunders. Thanks again. You can tell by the questions from the board that it's the topic that very much is in the forefront. Appreciate you taking the time to explain it better to us. Allows us to continue to do our job. So thank you very much.
Thank you very much. Thank you for the invitation.
Chief Johnson, I'll hand it back over to you to provide an update. Sarah.
Thanks, Board Chair. We're just switching presentations. So thank you, Board Chair, for the opportunity to highlight a few events and initiatives that have occurred in the last board meeting. I'll speak to the downtown deployment a little later, but certainly the introduction of Richard was very engaged officers in our downtown area. So on May 25th, Inspector Bouillard, along with members of the Barrie Police Service, attended the 6th annual Razors of Hope head shaving event in our community room right here at the Emergency Services Campus. Community member Jason Hellman organized the event yearly and supported the Terry Fox Foundation, raised a total of $8,375 over the past 5 years. The event was emceed by my predecessor, retired Chief Greenwood, and was well attended by community members, including His Worship Mayor Nuttall, Attorney General Doug Downey, MP Shipley, MP John Fassard, and Minister Andrea Kinch. Noted, the Barrie Police Service has launched a new initiative aimed at enhancing the sense of safety and security for all community members by increasing police presence and visibility in the downtown, parks, and surrounding areas. The initiative includes a team of downtown sworn officers and their special competent partners. This proactive measure is designed to ensure that residents and visitors feel safe and secure in their surroundings. Our community will see our highly visible members on foot, bike, e-bike, and even side by side. Our presence down there is to encourage interaction with all of our community members. On June 6th, Deputy Chief Burke, along with members of the Barrie Police Service, marched in the show of respect in the D-Day parade, commemorating the 80th anniversary of the Normandy landing. Second World War operations on D-Day, June 6, 1944, was the largest seaborne invasion in history. It enabled the Allied forces to begin the liberation of France from German occupation. Later that evening, Deputy Burke, along with other members, attended the sunset ceremony, which was held by the Grey and Simcoe Foresters at the Military Heritage Park to mark the special celebration.
On June 13th, we held our annual law enforcement torch run for Special Olympics Ontario, which helps support local athletes in our community. Members of the service participated in the run and were joined by local Special Olympics athletes who outran us, by myself and the deputy there. Stretching is incredibly important to be able to do so. On Thursday, June 13th, with Deputy Chief Burke and I attended the air show kickoff and celebrated the sponsors and partners who generously supported the air show and welcomed the pilots and performers once again to the city of Barrie. Seating, two gentlemen who have started in the past. On Saturday, June 14th and June 15th, members of the Barrie Police Service played a significant role in the success of the Barrie air show. There was an involvement from across the service, including auxiliary officers, special constables, sworn members, and communicators. All of whom did an outstanding job maintaining safety and security throughout the event. The Barrie Police Service would like to extend a special thank you to other police services who assisted in an event of this scale. We could not have done it without you. In particular, thank you to the York Regional Police Service, Marine and Dive Team, South Simcoe Police Service, the Rama Police Service, the Durham Regional Police Service, Ministry of Natural Resources and Forestry, the Ontario Provincial Police Health and Save Team, that's the Snow Vehicle and All-Terrain Industrial Enforcement Team, the police do like their acronyms, and the OTP Dive. These are our partners in public safety, and we are very, very grateful. Sergeant Dane Campbell from the Vancouver Police Department embarked on a cross-Canada journey on May 6th to support pediatric cancer. For the past 15 years, Dane has participated in the Cops for Cancer Tour de Coast, cycling over 12,000 kilometers and personally raising $140,000. So recently, his only connection to children's cancer was through those he met on the Cops for Cancer program. However, in late 2023, Dane's teenage daughter was diagnosed with a rare form of cancer. Following her diagnosis, Dane developed an action plan to raise even more awareness and funds for pediatric cancer. He decided to undertake a 7,000-kilometer cross-country cycling tour, aiming to complete it in 60 days. On June 8th, Dane arrived in Barrie, where he was greeted by Deputy Chief Burke and members of the Barrie Police Service and OTP cycling. Showing Dane around our beautiful city. Highlighted investigation. Suspect was arrested in the 2023 Ann Street explosion. On May 27th, 2024, detectives from the Barrie Police Service Street Crime Unit arrested a 36-year-old male. He's located in Ajax and taken into custody without incident. Through the course of what was a very complex investigation, it was determined the male was identified as being involved in the September 27th, 2023 explosion that had taken place in the parking lot of 108 Ann Street. As a result, a warrant was issued for his arrest. The accused has been charged with causing an explosion, intent to destroy, arson, damage to property 2 counts, possession of explosives, making or possession of explosives, breaching prohibition orders 2 counts, and failed to comply with a release order. He was held in custody and remanded to appear by video with the Ontario Court of Justice, located in Barrie, on June 4th, 2024. Barrie Police Service Major Crime Unit, who coordinated and led this investigation, wish to acknowledge, as does the rest of the Barrie Police Service, acknowledge and thank the community for their patience, input, support, and understanding over the past 8 months while this investigation was carried out, culminating in the arrest. Yesterday, June 19th, an officer from the Barrie Police Service who was working in the Cedar Point Drive at Dunlop Street West area was advised of a suspicious package that appeared to have been left at a business located in the Cedar Point Business Department. Barrie Police Resources immediately responded into the area, and Cedar Point Drive is closed from Dunlop to Edgehill Drive. In the interest of public safety, a number of nearby businesses were evacuated, while members of the Barrie Police Service Explosives Disposal Unit, the Tactical Support Unit, arrived on scene. Additional resources from the Barrie Fire Services, Fire and Emergency Services, and County of Simcoe Paramedic Services were also present. As the investigation continued, Barrie Police learned that the package was actually monitoring equipment that had been placed at the location earlier in the morning. The road closures were released just before noon, and the business owners were permitted to return. Once again, the Barrie Police Service wish to thank the public for their patience and understanding of this incident was investigated and the impacted area. On Tuesday, June 18th, 2024, members of the Barrie Police Service and the Barrie Police Service Board met and had an in-depth discussion about the Barrie Police Service and strategic direction. The day included discussions around visions and goals for the Barrie Police Service, including learning about leadership's visions and goals for the police service, aligning our work with key projects to support our goals, efficiency and change, finding ways to innovate while keeping things running smoothly, perceived and actual safety concerns, improving how we connect and serve with our community, improving internal communication channels, and fostering professional growth and job satisfaction among all members. Day was wrapped up with Deputy and I in the hot seat answering questions from the attendees. A very special thank you to our community there, folks. The volunteer Police Service Board Chair Ferguson, who willingly participated with our training unit in demonstrating our virtual reality training equipment. This type of technology enables us to more effectively and efficiently expose our members to a greater variety of training scenarios. And with that, Chair, I hand it back to you and thank the board for the opportunity to address the board and our community.
Thanks, Chief. I'll just make a quick comment with respect to the last slide. Yeah, I think it's we get together and look at our strategic plan. I find it very, very valuable as a board member to sit in and hear what I'm saying. This is really structured, obviously, but the conversation can go in here. I'm finding it very valuable. Questions for the chief with respect to his report.
Not so much a question, but a comment, just thanking the service for the initiative around the downtown. And I've heard such positive feedback directly from community members and also indirectly as I walk, behind people on the street and I hear them say, "Oh, wow, look at these police officers." Like, "Oh, I've never seen police on bikes down here before. Oh, the police are in such bright outfits. Look at that. There they are." Like, there's lots of that conversation happening between people walking on patios, and everyone seems really positive about seeing that increased presence. And I would also say that I've noticed that the police that are in that unit are very approachable. I've seen people stop on bikes, people stop on foot, interacting with community residents, answering questions, giving corrections, just, generally having conversations like with small kids. So kudos to the officers that you have in the downtown unit. They're doing an excellent job.
Through you, board chair, thank you. I think that we certainly pass along compliments as for the board's heard, as well as the public and many of you all are even be stated these functions like part of our legitimacy in our community, which to our community. Understand. So we want to see it more like love to see us you understand. Those individuals down there, much like the rest of our officers and the our community, we have public service.
Any further questions or comments for the chief? None. A motion to move in camera to discuss personal and legal matters in accordance with section 44, sub 1, sub A of the Community Safety and Policing Act. Those in favor to go in camera? We will go in camera. Deputy and chief, if we could stay in the in camera, please. Tom, you're welcome to that.